Welcome to part 3 of the EA Tax Training Enrolled Agent Exam Preparation course. My name is Tom Norton. I am both a certified public accountant and an enrolled agent, and I will be your guide and instructor throughout this course. Part 3 of the EA exam is all about representation, practices, and procedures. Basically, it covers how enrolled agents should interact with their clients and with the IRS, and the penalties for failing to act in a professional, ethical manner. In part 3, there are a lot of slides with a lot of words. I am not going to read all of those words to you. You can get a copy of the slides by following the link in the description of the video, and you should use them to study. As I go through the slides, I will talk about the most important issues and the ones that might need a little extra explaining. But just because I don't mention something that's on the slide doesn't mean it's not important or that you should ignore it. You should watch the videos and study the slides, whether I specifically mention something about it or not. With that out of the way, let's look at what we have in store in part 3. We've got 4 videos for you in part 3. This first video you're watching now is about practices and procedures. Second video is about representation before the IRS. The third video is specific areas of representation. And then finally, video 4 is all about the filing process. As always, I look forward to guiding you through all of these topics. And one reminder again, the 2024 EA exam covers the 2023 tax year. So if you're studying for the 2025 exam, you'll want to take note of the inflation adjustments that apply to some of the dollar figures you see in the tax law. So without further ado, let's jump right into video 1, practices and procedures. Specifically, what we will cover in this first video is practice before the IRS, becoming an enrolled agent, practitioner duties and restrictions, sanctionable acts, and rules and penalties. Of course, we have free resources from irs.gov, but I'm going to really highlight it in this video and for all of part 3. You must get Circular 230, Regulations Governing Practice Before the Internal Revenue Service. It is not just a recommendation. Really, if you want to pass Part 3, you need to get and read and study Circular 230. Also, you need to get Publication 947, Practice Before the IRS and Power of Attorney. These 2 publications is most of what you need for part 3 of the exam. I have put the most salient issues on the slides. That is true. So the slides to this course are going to be very, very helpful for you. But still, even with that, you will definitely want to read Circular 230 and then also go through that Publication 947. This is what the front page of Circular 230 looks like. You can see it's a different format than, for instance, the IRS publication. So this is actually technically the Treasury Department. Now, the IRS is part of the Treasury Department, but this is called Treasury Department Circular number 230. And you can see that it was last revised in June of 2014. That's right, about 10 years ago was the last time it was revised. They are working on another revision, but as of right now, and for the 2024 exam and even the 2025 exam, what we are dealing with is this June 14 edition of Circular 230. So this is what the first page of that looks like. Practice before the Internal Revenue Service. When we say practice before the IRS, what do we mean? Well, here's what it is. Practice before the IRS includes all matters relating in any way to any of the following: communicating with the IRS on behalf of a taxpayer in any way, representing a taxpayer at conferences, hearings, etc., preparing, filing, or submitting documents, including tax returns with the IRS, and providing a client with written tax advice on one or more federal tax matters. You will want to know this. This will be questioned on the exam. When somebody says, what does it mean, practice before the IRS? This is what it means: communicating, representing, preparing, and providing written tax advice. Those things are what practice before the Internal Revenue Service means. The following individuals have full practice rights to represent taxpayers before the IRS and are subject to Circular 230: attorneys, certified public accountants, and enrolled agents. So you are studying these slides presumably to become an enrolled agent. So you will see, once you become an enrolled agent, you will have the same standing before the IRS as far as representing clients as attorneys and certified public accountants. And attorneys you need a bachelor's degree plus 3 years of law school plus pass the bar exam to be an attorney. To be a CPA, you need a master's degree or at least a bachelor's degree with additional hours equivalent to a master's degree. Plus, you need to pass a very rigorous exam. Plus, in most states, you need some experience, a year or two of actual experience working in order to be a CPA. In order to be an enrolled agent, you do have to pass the exam, the 3-part exam, and you have to pass a background check. But you don't need nearly the same amount of education and training as an attorney or a certified public accountant. That's why becoming an enrolled agent is such a great deal, because you get all the same privileges before the IRS without having to go through years and years of education and experience in order to get it. So the attorneys are licensed by each state. Certified public accountants are licensed by each state, and each state will have slightly different requirements for how to get those. Enrolled agents are enrolled by the Internal Revenue Service, so it's standard across the country, and it is done directly through the IRS. And so the IRS feels confident enough in their own system of testing that they feel like if someone has gone through, has passed the exams, has passed the background check, then they are entitled to full practice rights before the Internal Revenue Service. So congratulations to you on becoming an enrolled agent. Now, there are some others who have what are called limited practice rights before the Internal Revenue Service. First of all is the AFSP program. This is the annual filing season program for tax preparers. So this is for tax preparers who take a minimum amount of continuing education hours each year and who have this annual federal tax refresher each year and pass that exam every year. They also must have a PTIN, which we will talk about PTINs later, and they have to consent to regulation under Circular 230. What this allows them to do is to represent taxpayers only for tax returns that they personally prepared and signed, and only in front of frontline IRS employees, so revenue agents, customer service agents, etc. They can represent clients for tax returns that they prepared and signed in front of those frontline employees. But if you get anywhere beyond that, so if you're starting to talk about now you're going to have an audit and there's going to be an audit conference that's going to involve more than just a revenue agent, there's going to be supervising agents there, etc., then these AFSP preparers can no longer represent that client. Also, that preparer must be qualified under the AFSP program, both for the year of the tax return itself and the year of representation. So obviously audits typically happen in later years. You file the return one year and it gets audited a couple of years later, for example. So in order for this AFSP preparer to represent the taxpayer at all, they have to have been an AFSP preparer both in the year that the return was filed and in the current year. So that is what limited representation looks like for those preparers. Unenrolled tax preparers who are not AFSP preparers, so they're not enrolled agents, they don't have this AFSP designation, they have virtually no representation rights for any tax return. So you don't have to be an enrolled agent or an AFSP preparer in order to prepare tax returns for money. You do have to do a couple of other things, mostly get a PTIN, but you don't have to go through these programs in order to prepare taxes for money. But if you're not enrolled or a member of this program, then essentially you have no representation rights before the Internal Revenue Service. There are others who also have limited practice rights before the IRS. Appraisers, they don't really get to represent the client, but they can appear as a witness. So sometimes in the tax law, there are things where you go out and you get an appraisal. So for instance, for a charitable contribution, you might get something appraised and you hire an appraiser to do that. They can come in and act as a witness if there is an audit, for instance. Enrolled retirement plan agents, they can represent taxpayers in their area of expertise. Same way with enrolled actuaries. And then there are low-income taxpayer clinic student interns. So there are around the country, some of them are even sponsored by the IRS, low-income taxpayer clinics where people who don't make much money, usually they are poorer and disadvantaged and they don't really understand taxes. They can go to these clinics and there will be tax preparers there who will help them and will fill out their tax forms for them. So this is something, by the way, that you as an enrolled agent can go and volunteer to do this as well. And it is all on a volunteer basis. But in any case, sometimes they will use students. They'll use law students, accounting students, etc., to help out at these clinics. If they are supervised by a practitioner, such as an enrolled agent, then they can request authorization from the IRS to represent a taxpayer before the IRS, and the IRS can grant that if they want to. Now, there are certain others who can practice before the IRS if they have a special relationship to the taxpayer. So it's kind of like related parties. So first of all, an individual can always represent themselves. So if you having your tax return audited, it doesn't matter. You don't have to be an accountant or an enrolled agent or anything like that. You can always represent yourself. Similarly, with an immediate family member, which is limited to a spouse, a child, a parent, a brother, or a sister, but you don't have to have any special credentials in order to represent an immediate family member. An officer of a corporation, association, or an organized group can represent that entity before the IRS. A general partner in a partnership can represent the partnership before the IRS. Any full-time employee can represent an employer in front of the IRS, and a fiduciary, so like a trustee, an executor, personal representative, etc. They're not really representing the client. They are standing in the position of the client. So it's as if they were the client. So they can be there also to represent that client before the Internal Revenue Service. So who cannot practice before the IRS? Well, essentially anybody we haven't already listed. And entities, corporations, partnerships, or other entities cannot represent a client. It has to be an individual. So, for example, if you have a law firm, you cannot just appoint the law firm to represent you before the IRS. It has to be specific lawyers in the law firm. So they have to be named by name that this lawyer or these two or three lawyers can represent me before the Internal Revenue Service, not just that the whole firm itself can do so. And then anyone who has been disqualified by the IRS cannot represent other taxpayers before the IRS. So we'll talk about in this video how a person might come to be disqualified. But once they are disqualified, as we'll see, then they cannot represent other taxpayers before the Internal Revenue Service. PTIN requirements. We've talked about the PTIN already a couple of times. First of all, it stands for Preparer Tax Identification Number. So the IRS defines a tax preparer as anyone who participates in the preparation of tax returns for compensation. It doesn't matter if they are full-time, part-time, or casual preparers. So if you participate in the preparation of a tax return for money or any other type of compensation, then you are a tax preparer and you need to have a PTIN, a Preparer Tax Identification Number. Even if you are not the one signing the tax return, if you participated in the preparation of that tax return, then you need a PTIN. And it doesn't matter if you are an enrolled agent, a CPA, or an attorney or not. If you are getting compensation for preparing a tax return, then you are a tax preparer under the IRS's definition, and you need a PTIN. You get the PTIN by going to the IRS website and paying the fee. The fee right now is somewhere around $19 or $20 per year. When you register for that PTIN, you do have to undergo a limited tax compliance check to make sure that you are up to date on your own personal and business tax return. So they will take, as part of this application, you have to put in your social security number and the employer identification number of any entities that you are involved with. And you have to say, yes, I am up to date on filing all my tax returns. And then they're going to go and check that out. So they're going to go and make sure that you have, in fact, filed all your tax returns and paid all of your taxes. Now, I say paid all of your taxes. It is okay if you are in a plan with the IRS to pay off a balance. So in other words, you had a balance due, you couldn't pay it all, so you entered into an agreement with the IRS. Okay, I will pay so much per month for this many months until it's all paid off. It's fine for you to be in that type of plan as long as you are up to date on your payments. So you must have filed all of the tax returns that you were supposed to have filed, and you must be up to date on paying all of your taxes. And if you do those things, then they will issue you a PTIN, and then you do have to get that renewed each year. And again, make sure that you are up to date on your taxes, etc. So now let's talk about becoming an enrolled agent, which is what you are here to do. So what are the steps and how does it all work? Well, there are two paths to becoming an enrolled agent. The first path is by examination, and again, I presume that's why you're here. So you apply for and pass the 3-part EA exam. Officially, it is called the Special Enrollment Examination, or SEE. Within 1 year of passing the final part of the exam, then you apply on this Form 23, and then you have to pass a background check and a tax compliance check that is conducted by the IRS. And when they do the background check, if you have ever engaged in any activity which would result in suspension or disbarment under Circular 230, which we're going to talk about later in this video, what that means. So if you've ever done any of those things that would get you disbarred if you were a tax preparer, then they are not going to allow you to become an enrolled agent. But other than that, there's no special education requirements like you have to be an attorney or a CPA. So as long as you can pass all 3 parts of the exam, pass the background check and the tax compliance check, then you will be able to become an enrolled agent. So that is the first path to becoming an EA. The second path is for previous IRS employees. So if you were an employee of the IRS for at least 5 years in a position that involved interpreting and applying the Internal Revenue Code and regulations, then you may qualify to become an enrolled agent without having to pass the EA exam. You must apply, though, within 3 years of leaving that position. So you want to remember this for the exam. you had to have had 5 years of experience in a position that involved interpreting and applying the Internal Revenue Code, and you must apply within 3 years of when you left that position. Then you are going to fill out the same application and pass the same background and tax compliance check. So those are the two ways that you can become an enrolled agent. Renewal. Enrolled agents must renew their enrollment every 3 years, and you do it by filing this form 8554, which you can just do it online. It is fairly easy to do. And the year in which you renew depends on the last digit of your Social Security number. So if your Social Security number ends, the last digit, if it ends in 0, 1, 2, or 3, then your re-enrollment period is November 1st of 2024 to January 31st of 2025. If it ends in 4, 5, or 6, it's 11/1 of 25 to 1/31 of 26. And if it ends in 7, 8, or 9, or if you don't have a Social Security number, then you renew from November 1st, 2026 to January 1st of 2027. And then this is just going to roll over. So the next year, November 1st of 27 to January 31st of 2028 is going to be again for those whose ends in 0, 1, 2, or 3, and it's just going to keep rolling, so on and so on. Continuing education. So once you become an EA, your education is not over. During each 3-year renewal cycle, you must have at least 72 hours of qualifying continuing education. And again, you are going to want to know all the numbers on this slide. So you have to have at least 72 hours of qualifying CE every 3 years. Each year, you have to have at least 16 hours of CE, including at least 2 hours of ethics. So if you look at 72 hours over 3 years, that's an average of 24 hours per year. But you don't have to get exactly 24 hours each year. But at the same time, you can't just wait and get all 72 hours in the third year. So you have to get at least 16 hours in any one year. And each year, you have to get at least 2 hours of ethics. So 2 hours of ethics times 3 years means you have to have 6 hours of ethics over the 3 years. That is included in the 72 hours. In other words, you have to have 72 hours in 3 years, including 6 hours of ethics. So you can have 66 hours of other topics and 6 hours of ethics, and that will give you your 72 hours. Now, you can have more than 6 hours of ethics. That's just a minimum. But it's not just 6 hours of ethics over 3 years. It is 2 hours each and every year. So you have to make sure every calendar year that you get in at least 2 hours of ethics. You also have to make sure every calendar year you get in at least 16 hours of total amounts of CE. And then over the 3 years in total, you have to get at least 72 hours. For new EAs, so in the year that you become an EA, so during that first cycle, you have to get 2 hours of CE for each month, including the month of enrollment, and 2 hours of ethics annually, which also counts towards your total CE requirement. So we are going to do an example to look at that. Elizabeth became an EA on August 24th, and based on her SSN, it was her 3rd year of her enrollment cycle. So that means she's going to have to renew. So she just started on August 24th, and now she's going to have to renew between November 1st and January 31st. She must take at least 10 hours of CE, 2 hours each for August through December, and that has to include 2 hours of ethics, and she has to do that by December 31st. So she has to look and say, okay, I became an EA on August 24th. So I need 2 hours for August. Even though it's towards the end of August, she still has to have 2 hours for August, not necessarily in August, but we have to count August. So she needs 2 hours for August, 2 hours for September, 2 hours for October, November, and December. That's 5 months. So by December 31st, she has to have 10 hours of CE, and at least 2 of those hours have to be ethics. Now, she can wait and get them all in December if she wants to. Heck, she could get them all on December 31st if she wanted to, but she has to get a total of 10 hours by December 31st, and at least 2 of those hours have to be in ethics. When you're taking these continuing education courses, all the courses must be provided by IRS approved CE sponsors. So when you are choosing a CE sponsor, and there are lots of them out there, you want to make sure that they are IRS approved and that the specific courses you want to take are approved by the IRS. So these providers, first of all, they have to apply to be a provider. They have to pay an annual fee to be a provider. And then they have to submit their courses to the IRS for the IRS to review and to say yay or nay that this course is approved. And so you want to make sure that the provider themselves is IRS approved and that the particular courses that you want to take are IRS approved. You get an hour of credit for each 50 minutes of instruction. So they allow for a 10-minute break for every hour. An enrolled agent may earn up to 6 hours for teaching qualified courses. They get 1 hour for each hour spent actually teaching and 2 hours for preparation for each hour taught. So if you were to teach a 2-hour course, for example, you would get 2 hours for the actual teaching time, and then you would get 4 hours for the preparation time. So that would give you 6 hours. And 6 hours each year is the most you can get for teaching. So the rest of your hours are going to have to be actually taking courses. You can't fulfill all of your requirements just by teaching, only 6 hours per year. CE providers report electronically to the IRS the PTINs and the names of the people who took their course. Even so, you are responsible for obtaining and keeping your course completion certificates, and the IRS has the right to audit your CE. So when you go and you take these courses, it'll all be done electronically. So you can take the course online or you can take it in person. It doesn't matter. There's some courses that are live. You go, you show up to some venue, and there's an instructor right there in front of you. It might be at a hotel meeting room or something like that. And you go, the instructor's right there. You fill out your name and your PTIN. They make sure that you're there and that you go through the course. And then they will enter everything in the system and it will electronically be transferred to the IRS. There is also online training. So there can be webinars where you go and you watch like a Zoom type of thing or just a webinar. And then you get credit for that. Again, you have to fill out all your information. And usually they will make sure that you're there and actually watching by making you answer questions as you go through. Now, you don't have to get the questions right. It's not a matter of did you get the answers right or not. They're just attendance checks. So you answer the questions to make sure you're actually there watching and you didn't just turn on the video and walk away and go do something else. So that's another way you can do it. There's also self-study where there's no video involved. Maybe there could be a video involved, but it could just be you're reading through and you read through all of the different course material, and then you have to take a test at the end to make sure that you actually read and understand material. So there's all these different formats, but whatever it is, then that provider will electronically transmit your information to the IRS, say, yes, this person did in fact take and pass this course. And you can go at any time, the same place where you register for your PTIN, you can go and look and see what courses that you have gotten credit for. So obviously, every year you want to make sure that the courses you took have been reflected in that online record. And so in order to do that, you're going to get a completion certificate when you take a course. I do recommend that you download that completion certificate and keep it just in case something goes wrong, that the CE transmitter made a mistake, didn't get to the IRS. So you want to keep those so you can prove that, yes, in fact, I did take this course. Now, the IRS will waive CE requirements in certain circumstances. You have to ask them to do it. They're not required to do it, but they might in these circumstances. If you've had health issues that you can document to show that you've not been able to take the courses, if you've been active duty military, they will likely waive it for you. If you've been absent from the United States due to employment reasons, they may waive it for you, and they could waive it for other reasons on a case-by-case basis. But I would not count on these things. You want to go ahead and get your CE requirements in, if at all possible. If for some reason you just couldn't do it, so for instance, health issues, you just were bedridden and just absolutely physically couldn't do it, well, then obviously you couldn't do it. So then you would ask the IRS for a waiver. But this is going to be relatively rare, and you don't want to count on it. You want to do everything you can to get your CE hours in, and you want to know all of those requirements for the exam because they will be tested. Sometimes your enrolled agent status may become inactive or it might be terminated. So if you do not meet your CE requirements or other renewal requirements, so for example, if you're not up to date on filing and paying your taxes, then your enrolled agent will be placed in inactive status. And you have 60 days from being notified to respond and provide proof of the missing requirements. So if they don't see that you have got all of your CE, they're going to send you a notification saying, hey, you're going to be made inactive because you don't meet the requirements. You've got 60 days to respond. Again, that's a number you will want to remember for the EA exam. If you miss your renewal cycle, so you have to do it by January 31st, if you miss that, you can do it late, but you've got to pay your fees for the prior and current cycles, and you have to provide proof of your CE compliance. And you can lose your eligibility to practice if you don't meet your requirements. If you don't renew your PTIN, so remember you have to renew that each year, you can actually request to be placed on inactive or retired status. And you can also lose your eligibility for being disciplined by state regulatory agencies, for example, by being disbarred or losing your CPA license. So some of us are both CPAs and enrolled agents, and there are some people who are both attorneys and enrolled agents. So if you lose your law license or your CPA license, then the IRS is also going to take away your enrolled agent status if the reason you lost it is because you were disciplined. If you just voluntarily gave it up, then that's okay. That's not going to automatically mean you lose your enrolled agent as well. But if you were disciplined by your state regulatory agency and as a result of that lost your license to be a lawyer or a CPA, then you're also going to lose your enrolled agent status. So now let's talk about practitioner duties and restrictions, and this applies to all practitioners who are subject to Circular 230, which includes, of course, enrolled agents. Information to be furnished. Practitioners must promptly submit records or information that are requested by the IRS. So if you've got records and the IRS says, hey, we want to see those, unless you reasonably believe that those are privileged, and we will talk about privilege in a later video. But in general, unless you reasonably believe those are privileged, then you need to turn those over to the IRS promptly when asked. If you don't have those records, but you know where those records are, then you need to tell the IRS where they can find those records. And you must not interfere with a lawful request for records or information. In other words, you can't go destroying documents that the IRS wants, or you can't go trying to tell the IRS, no, we don't know where those documents are, when in fact you do. You need to be forthright and honest with the Internal Revenue Service. And you're going to see that as a theme throughout this video. You are expected as a tax practitioner to be honest with your clients and with the Internal Revenue Service at all times. Knowledge of a client's omission. We talked about this in a previous video, but let's go over it again. If you know that a client has not complied with the tax law, or they've made an error on a tax return or other document that has been supplied to the IRS, then what should you do? First of all, you should promptly advise the client of the problem. So you need to say to them, hey, look, let's say you're looking at a previous tax return and you know that there's an error. You need to let the client know about it right away, and you need to advise the client of the consequences of not correcting the problem. You'd have to say, hey, look, you're going to owe approximately this much in tax plus penalties and interest, for example. Now, you do not have a duty nor the right to report this situation to the IRS or to make the correction without the client's consent. It is the client's choice. You are going to promptly advise them of the issue and of the consequences of not correcting it. But it is not your choice of whether or not they correct it or what they do about it. It is the client's choice. So you do not go run off to the IRS and tell them about this. Not only do you not have a duty to do that, you don't have the right to do that. So again, we're going to talk in another video about privilege between a tax practitioner and their client. There is a right of privacy. It's limited, but there is a right of privacy between a tax practitioner and a client, similar to what you hear about an attorney-client privilege. So you're not going to go tell the IRS about it, but you are going to tell the client about it, and then the client is going to decide what to do. Due diligence. So a practitioner must exercise due diligence in preparing or assisting in preparing tax returns or other documents that are filed with the IRS, in determining the correctness of oral or other representations that are made by the practitioner to the IRS. So if you are telling the IRS something, if you are conveying information to the IRS on behalf of the taxpayer, then you need to take reasonable steps to make sure that what you are telling the IRS is in fact truthful. You don't have to necessarily do a full audit of what you've been told, but you have to reasonably believe that what you are telling the IRS is true and accurate. And then also, you must exercise due diligence in determining the correctness of representations that you make to your clients. So if you are telling the client, hey, this is the way the tax law works, then you need to make sure that you're telling them the truth, that you understand the issue and that you are giving them the correct advice. Or if the IRS communicates to you something about the situation, you need to accurately represent that to the client. This is what the IRS is saying, and this is what they mean. So just think about what would a reasonable, well-informed tax practitioner do in this circumstance. You need to use that amount of due diligence to make sure that what you are telling the client and what you are telling the IRS is in fact accurate. When it comes to relying on others, a practitioner will be presumed to have exercised due diligence when relying on the work product of others, as long as the practitioner used reasonable care in engaging, supervising, training, and evaluating that person. So let's say you don't have personal knowledge of the situation, but somebody that works for you comes to you and says, hey, I looked into this. This is what it says. You are allowed to rely on what they say, as long as you have used reasonable care in hiring and training that person. Or you might sometimes be relying on another practitioner outside of your firm. Let's say you got a K1 from a partnership. Your client got a K1 from a partnership. It's reasonable for you to rely, even if you didn't prepare the tax return of the partnership and you didn't prepare the K1, it's going to be reasonable for you to rely on that other preparer as long as you don't have any reason to think that you shouldn't rely on them. In other words, if you know that that preparer is a charlatan and that they're committing tax fraud, then it wouldn't be reasonable to rely upon them. But if they're just another tax preparer like you are, it's reasonable to rely on their work when you are communicating with the IRS. There are special due diligence rules. We talked about this somewhat in part 1, but we'll go over it again. When you are dealing with these credits, the American Opportunity Credit, the Child Tax Credit, credit for other dependents, the Earned Income Credit, head of household filing status, then you've got that special form, you may remember, that you had to fill out, that 8867, which is your due diligence checklist. So when it comes to those, you have to have a higher level of due diligence than you do for other issues. So you have to go through and you have to verify all of those things that make the people, the taxpayer, eligible for those credits. So the way you meet this knowledge requirement is by interviewing the taxpayer and taking notes, documenting everything you asked and what the answers were, reviewing all of the information and making sure it's adequate to make sure that they are eligible. You must not know or have any reason to know that anything that they're telling you is incorrect. And you got to make reasonable inquiries if something just doesn't seem right. For this 8867, you have to keep the records for at least 3 years. So you keep the 8867 itself, any worksheets and computations that you used, any documents that you reviewed, the records that you kept. You want to keep all of those for at least 3 years. And if you do not do those things, then you can face penalties for not complying with those rules. Prompt disposition of pending matters. A practitioner may not unreasonably delay the prompt disposition of any matter before the IRS. So you want to take care of things promptly. Usually when you get some sort of letter or notice from the IRS, it will say that you should respond within a certain number of days. For instance, it might say you must respond within 30 days. So you want to make sure that you respond within 30 days. And in general, you don't want to unnecessarily delay IRS proceedings. You want to get things taken care of in a timely fashion. Assistance from certain persons. So you may not knowingly employ or accept assistance from anyone who is not eligible to practice before the IRS. And any person who is a former government employee who personally and substantially participated in the matter at hand. So that is going to lead us to this next point. A former government employee and anybody they work with cannot work on a client matter if that former government employee was involved with it when they worked for the government. So let's say you have somebody who worked for the IRS and they were involved with an audit of the taxpayer. They cannot then leave the IRS and go to work assisting that taxpayer with that audit. And I think this is for obvious reasons. You don't want taxpayers saying, hey, to the IRS employee who's doing their audit, saying, hey, I'll pay you this large salary if you come work for me and represent me before the IRS. Not allowed to do that. So that's why they're saying up here, if you're a practitioner, you cannot accept assistance from any former government employee who is doing that. You can also not accept assistance from anybody who has been suspended from practice before the Internal Revenue Service. Notaries, if you are a notary, that's okay to be a notary, but you cannot notarize any documents for any clients that you are representing before the IRS for that matter. So if you're representing them in an audit, for example, and they're going to sign something and it has to be notarized and you're the one representing them, you cannot also notarize the document. I think that makes sense. It's a conflict of interest. Fees. Practitioner fees cannot be unconscionable. You will want to remember that word. That's kind of a lawyer word, but that's what's in Circular 230. Fees cannot be unconscionable. So this is not specifically defined, but it just means the fees need to be reasonable based on the services that were provided. And in general, you cannot charge what are called contingent fees. So a percentage of the refund, for example. So you can't say to someone, hey, I'll do your Form 1040 and I'm such a good tax preparer. I know I'm going to get you a big refund. So instead of charging you a flat fee for preparing your return, or instead of charging you an hourly fee for how much time I spent, I'll just take a percentage of your refund. I'll take half of your refund and you get the other half or something like that. That is not allowed. They do not want to tempt tax preparers to fudge on the tax return and to make things up in order to get a larger refund so that they can get a larger fee. So you are not allowed to take a contingent fee. Now, there are a few exceptions to the contingent fee rule. You can charge a contingent fee related to an IRS audit of an original tax return or an amended return as long as the claim was filed within 120 days of when the taxpayer received the written notice of the audit. So if, for example, the client gets audited and the IRS says, well, you owe $20,000 in back taxes, you can, as a tax practitioner, if you want to, you can say, hey, look, I will take a percentage of the amount that I save you. So they say that you owe $20,000. If I get that down to $10,000, then I will get a percentage of the $10,000 that I saved you. You can charge a contingent fee in that type of circumstance. Also, you can charge a contingent fee for services rendered in connection of a claim for credit or refund solely in connection with a determination of statutory interest or penalties assessed by the IRS. So, in other words, if the taxpayer has gotten hit with a big bill for penalties and interest, and you think that you can get those penalties or interest lowered by negotiating with the IRS, then you can say to the client, hey, I'll take as my fee a percentage of whatever I save you in penalties and interest. That is allowed. And you can charge a contingent fee for services rendered in connection with any judicial proceeding arising under the Internal Revenue Code. So this is aimed mostly at attorneys. Attorneys often work on a contingent basis. If they sue someone, they get a percentage of whatever they gain in the lawsuit. So this is a similar idea that if it's a judicial proceeding, then they can take a percentage of whatever was awarded or saved in that judicial proceeding. Return of client's records. So if a client asks for their records back, you have to give them their records back. That's what this is saying. However, their records does not include your work product or any tax returns that you prepared if they have not paid for them. So let's say you go through all the work of doing the tax return and they don't like the answer. Let's say they end up owing money and they think that you're wrong and they don't like that they owe money. So they're going to go find somebody else to do their tax return. That's fine. Any records that they have given you, you have to give them back so that they can go and take it to a different tax preparer or do whatever they want. But you don't have to give them your work product, your schedules and calculations and everything that you've done. And you do not have to give them a copy of that tax return if they have not paid for it. So even though you prepared it and it's sitting there ready to give to them, if they haven't paid for it, you don't have to give it to them. That's what this is saying. But you do want to know that you have to give them their records back promptly if they request them. Conflict of interest. So, in general, you must not represent a client if there's a conflict of interest, which means representing one client will be directly adverse to another client, or there's a significant risk that you won't be able to really do a good job for that client because of a conflict of interest or because of a personal conflict that you may have as the practitioner. So let's look at this first one. Representation of one client will be directly adverse to another client. An example might be you have a married couple that you do their tax return. Maybe you've been doing their tax return for years. Now they're getting divorced, and it's kind of a nasty divorce. And one of the parties, one of the spouses, says they want to hire you to help them with all the financial and tax implications of the divorce. Maybe they even want to hire you to be an expert witness. But in order to do that, of course, that's going to be adverse to the interest of the other spouse, who is also your client. So you would not be able to do that. You'd have to step back and say, no, I cannot represent either of you individually in this divorce proceeding. It could also happen of a corporation. Maybe you do the tax returns for a corporation. You also do a tax return for the CEO. And now the CEO is leaving the company and there's some sort of disagreement or lawsuit between the CEO and the corporation. And one or the other wants you to help with that lawsuit, to be an expert witness or to otherwise lend support in that lawsuit. You'd have to step back and say, no, look, both of you are my clients. I can't represent one of you against the other one. And then this second one is just saying if there's any type of conflict that you've got, either with another client or with yourself, that just wouldn't be right. You just couldn't really do a good job of representing that client because of this conflict of interest. Or maybe it just wouldn't look right. Maybe you could do a good job, but to an outside party, it would look kind of suspicious that you were involved with this because of a conflict of interest. Then you cannot represent their client. Now, there is an exception to all of this that says that even if there is a conflict, if everybody agrees, so if you tell everybody, hey, look, I've got this conflict, and everybody says in writing that that's okay, we understand that you have a conflict, but we're going to allow you to represent this party anyway, then as long as that is not illegal, then it's okay for you to do that. So if everyone knows about it and agrees in writing that you can represent one client, even though you've got this adverse interest, then you can go ahead and do that. Advertising. You are allowed to advertise. However, that advertising cannot include anything that is false, fraudulent, or coercive, or misleading, or deceptive. So you will want to remember all of those things for the exam. You cannot have anything that is false, fraudulent, coercive, misleading, or deceptive in your advertising. Enrolled agents cannot use the term certified or imply they are employees of the IRS. So you can't say certified by the IRS. You cannot use that word, certified, and you cannot imply that you are an employee of the IRS. What can you say? These are examples of things you can say. Enrolled to represent taxpayers before the Internal Revenue Service. Enrolled to practice before the Internal Revenue Service. And admitted to practice before the Internal Revenue Service. So you can use those type of wordings, but you can't say certified or imply that you are an employee. You may not use official IRS insignia, such as those that you see on your screen. You cannot use those in your advertisements. However, you can use the authorized e-file logo, such as those that are shown here if you are e-filing tax returns. Fee information. So we talked before about the amount of your fees, but this is about how you advertise your fees. So you are allowed to publish a fee schedule showing all of this information. You can show fixed fees, you can show hourly rates, you can show ranges of fees, You can show a fee charged for an initial consultation. So you can do any of those things. However, you cannot charge any more than that for 30 days from when it was last published. So if you have on your website, for instance, that you give a free initial consultation, then you have to give a free initial consultation as long as that website is up and for at least 30 days after you take that statement off of your website in this example. And you have to keep a copy of any such advertisements for at least 36 months. So the IRS may want to come back and say, hey, what did you tell people you were going to charge? And you have to keep that information for at least 36 months. Solicitation, you are allowed to solicit business, such as through mailers, as long as it's allowed by state law. And these days, I'm not aware of any state that does not allow solicitation. There was a time many years ago when lawyers were not allowed to solicit business. So, like all of those advertisements that you see on TV for lawyers and all the billboards, those were not allowed at one time. And it was similar for CPAs. We're also not allowed to advertise or to send solicitations of any kind. But those things have all been lifted these days. Any solicitation, though, must clearly identify that it is a solicitation and, if applicable, provide the source of the information that was used to select the recipient. So how did you get their name? Why are you sending them this? You have to provide that information. And all solicitations have to meet the same requirements as other advertising. So it can't be false, misleading, etc. Negotiation of taxpayer checks. Don't do it. Okay. You may not endorse or otherwise negotiate any check issued to a client by the government in respect to a federal tax liability. This specifically prohibits directing or accepting payment by any means, electronic or otherwise, into an account owned by or controlled by the practitioner or any firm or other entity with whom the practitioner is associated. You cannot take your client's money. The money is coming from the IRS to the client. It needs to go to the client. It does not come to you. For whatever reason, tax practitioners do this. They have the money go directly to themselves rather than going to the client. That is a big no-no. This will be on the exam. You need to know that you cannot do this. You cannot endorse or otherwise negotiate any check issued to the client, and you cannot direct payment, electronic or otherwise, to one of your accounts or an account that you have anything to do with. Now, you might say, but hey, I've got a client, they don't have a bank account, so I'm just going to have the money go to my bank account, then I will give them the money and subtract my fee. No, no, and no, you cannot do that. There are other ways for that client to get that refund. They don't have to have a bank account. They can get a check. They can even get a debit card with the amount on there. There are other ways that they can get it. You do not have to put that money into your account, and you cannot have that money directed to your account. That is a big no-no. And nothing in Circular 230 or any of the regulations can be construed as authorizing non-attorneys to practice law. You are an enrolled agent. If you are not also an attorney, then you cannot practice law. And CPAs cannot practice law if they are not also an attorney. Best practices for tax advisors. So, tax advisors should provide clients with the highest quality of representation by adhering to best practices. Best practices include the following, and best practices can change over time with updates in technology and everything. These best practices can change, but these are the ones that are specifically listed for now. Communicating clearly with the client about the terms of the engagement. So often we will use engagement letters that spell out everything we're talking about as far as what we are going to do as tax preparers with those clients. You also want to make sure that you establish all of the facts and any assumptions for everything that you are dealing with the client. You want to advise the client of important conclusions that have been reached. and you want to talk to them about any possible penalties, any possible interest, etc. And of course, you want to act fairly and with integrity in practice before the Internal Revenue Service. And again, there can be a lot of other best practices, but this is just some of the ideas of what we want to do when we're dealing with our clients and with the IRS. Supervising others. So if you have the responsibility of supervising others, then you need to make sure that they're following these rules as well. That's what this slide is saying. You are their supervisor. You are responsible for what they do. So you want to make sure they are properly trained. You want to make sure that they are following all of the rules, and you can be held responsible for what they do. Standards with respect to tax returns. So you shall not willfully, recklessly, or through gross incompetence sign a tax return or advise a client to take any position that lacks a reasonable basis, that is unreasonable, that is a willful attempt to understate a liability, or is a reckless, intentional disregard of the rules and regulations. So again, you just want to make sure that if you are signing a tax return or advising a client, that you are doing so lawfully and ethically, and that you're not advising them to take a position that is completely ridiculous and that lacks any reasonable basis. And we're going to talk a little bit more about this reasonable basis and some other terms here in a little bit. When the IRS is looking at this, a pattern of conduct will be taken into account in determining whether or not the practitioner acted willfully, recklessly, or through gross incompetence. So, in other words, if you just did something one time, that is going to be looked at much differently than if you did this over and over and over again with all kinds of different clients. So you have these tax preparers that just go completely off the rails, and they make up tax deductions that don't exist. They make up tax credits that don't exist. And typically when they do this, they don't just do it once. They're doing it with all of their clients. And so the IRS is going to take in any pattern of conduct as a factor when they are looking at this and looking at how to handle that practitioner and what type of punishment that practitioner may get. When you are taking a return position, there are these terms that the IRS uses and these approximate percentages. So let's talk about these. When we say a position has a reasonable basis, what we are saying is that when a reasonable and well-informed analysis is done by someone who is knowledgeable in the tax law, that there would be at least a 25% likelihood that the position would be upheld on its merits. In other words, if you're taking a position on a tax return and you look and say, if this gets audited, what are the chances that the taxpayer is going to prevail upon audit? And let's say if it eventually went to court and a judge decided, what are the chances they're going to win? The taxpayer is going to win the case. If you look at that as a reasonable and well-informed tax preparer, and you say, well, they've got at least a 25% chance of prevailing, that is considered a reasonable basis. And you can go ahead and file the tax return based on that, even though it's only a 25% chance of prevailing. If you talk to the client, you let them know, hey, here's the situation. This is the position we're taking. We believe it is a reasonable position. It is a reasonable basis, which means it has at least a 25% chance of prevailing. If the client agrees, then you can go ahead and take that position on the tax return. However, you must disclose it. We'll talk about how you disclose it here in a minute. But you have to disclose on the return to the IRS, hey, we took a position on this return that we think only has about a 25% chance of prevailing. Next is a realistic possibility of success. So this is a 33% chance. So if you say, I think we've got about a 1 in 3 chance of prevailing, that is called a realistic possibility of success. You can take that position on the tax return. You do not have to disclose it. However, if you do disclose it, you can avoid penalties. So both the taxpayer can avoid penalties and you as the preparer can avoid any potential penalties if you disclose that on the return, but you do not have to disclose it. Next is substantial authority. So if you believe you've got a 40 to 50% chance of prevailing, that is called substantial authority. Does not have to be disclosed, but if you do disclose it, that avoids penalties. And then finally, we have more likely than not, which means it's got a greater than 50% chance of prevailing. That, again, does not have to be disclosed, but you can avoid penalties by disclosing it. So you will want to remember those and remember those percentages for the exam. So how do you make this disclosure? Generally, you make it on this form 8275 or 8275R. That's how you're going to disclose it. However, you need to know that this will not avoid penalties attributable to negligence, disregard of regulations, or a substantial understatement of tax on a tax shelter item. So you can't just disclose it if you're taking a position that is just a total disregard of the regulations and the rules, or if it relates to a substantial understatement of a tax shelter item. So let's talk for a minute about tax shelters. Certain tax shelters and related transactions are called reportable transactions or sometimes called listed transactions. So if you have one of these listed transactions, you have to disclose it on a different form, this form 8886. And these transactions are always subject to the more likely than not standard, so that greater than 50% standard. In other words, if you are dealing with a tax shelter with a reportable transaction, you cannot take a position that only has a 25% or a 33% or a 40 to 50% chance of prevailing. It has to have a more likely than not standard in order for you to take that position on the tax return. So remember that for a tax shelter has to be more likely than not if that's the position you are taking. Any tax return position you take is going to take into account many factors, including all of these things: Internal Revenue Code, the regulations, legislative history, etc. In video 2, we're going to go over each of these things in more detail. Just for now, know that when you are taking a tax return position, this is what it's based on. Basically, it's based on the tax law and IRS guidance and court guidance regarding the tax law. That's what that means. Standards for documents. You may not advise taking frivolous positions, and you may not advise submissions to delay or impede tax administration that are frivolous or that contain or omit information that demonstrates an intentional disregard of rules or regulations. So one of the things that this is talking about are what are called frivolous tax protester arguments. There are people who believe that the income tax is illegal or unconstitutional. And they'll go through all types of long explanations about why, because of this part of the Constitution or because of the way the 16th Amendment was passed, that there wasn't a quorum in Congress, so it really shouldn't even be in the Constitution, and all kinds of other arguments about why the income tax is not legitimate. And so they will file a tax return because they know that if they don't file a tax return, they're going to get in trouble. So they'll file a tax return, but they will cross out the statement that says, I'm signing this under perjury. And they'll basically say, I don't believe that the income tax is legal. That is a frivolous position. This has gone to the courts many times. It's gone all the way to the Supreme Court. The Supreme Court has said none of these arguments hold any water. And so anybody who makes those arguments is now considered to be making a frivolous argument. So you, as a tax preparer, cannot advise a client to take such a position or help them to take that position or any other frivolous position, meaning just completely ridiculous, off the rails, not supported by the law type of position. You cannot advise a client to do that or assist a client in making any of those types of claims. You must advise a client of potential penalties, as we have talked about before. So if you're taking a position on a tax return that you either sign the return or you advise the client, then you have to tell them of the potential penalties for taking that position. And you must advise the client that they could potentially avoid the penalty if they disclose that position, as we have previously discussed. Reliance on client representation. You may, in general, rely on what the client tells you. If the client tells you something and it seems reasonable and you have no reason to think that it's not true, then you can rely on that. You do not have to ask them to prove everything they say. You are not an IRS employee and you are not an auditor. You do not have to say that, oh, I need to see every receipt for everything you're deducting here. If the client tells you something, you have no reason to believe it's not true and it is reasonable, then you can rely on that. If something doesn't seem reasonable, then that's when you would want to make inquiries and maybe look at documentation at that point. Competence. You must be competent to do whatever work you are doing for the client. And this is important. And this doesn't just apply to us as tax professionals. This is any professional. So if you think about it, let's say you broke your arm and you've got a friend who's a doctor and they're a psychiatrist. So they've been to medical school. They are a medical doctor. Well, if you go to them, say, hey, I broke my arm. Can you help me? You would hope they're not going to say, well, yeah, I've been to medical school. Here, I'll set your arm and put you in a cast. That's not what they do. They are a psychiatrist. So what they would say to you is, hey, look, it's true that I'm a doctor, but I'm not an orthopedic person. I'm not an emergency room doctor. You need to get to the emergency room and let them take care of you. I cannot help you. I am not competent to help you with your broken arm. And that's perfectly fine. As a matter of fact, that's what we would want them to do, right? We don't want them working on our arm if they don't know how to work on our arm. So the same type of thing applies to lawyers, to CPAs, and to enrolled agents. If somebody comes to you with a tax matter that you just don't know anything about, you're just not competent to do it, then you should say, hey, look, that's not my area of expertise. You need to find somebody who can help you, and maybe you can help them, refer them to somebody, but you shouldn't do it yourself if you're not competent to do it. Now, that doesn't mean that you can't become competent. That doesn't mean that you can never do anything that you've never done before. So you can see here, you can become competent through various methods, such as consulting with experts or studying the relevant tax law. So if it is something that is pretty straightforward, that you can just go either consult with somebody that knows about this, or you can just go and read the law and do some research and get yourself up to speed on it real quick, then that's fine. You can become competent in that in a relatively short period of time in some instances, and then that is fine. So you don't have to turn away everything just because you've never done it before. But if you start looking into something and you just realize that, hey, wow, this is way above my level, and there's no way I'm going to become an expert on this with a few hours of studying, then you need to politely tell the client, sorry, I can't help you. maybe here's somebody else that can help you. So that's what this is saying. You need to be competent or able to become competent in a short amount of time in order to take on client work. And if you are not, then you need to decline that work. And by the way, wouldn't you want to do this? Do you really want to get involved in something that you don't really understand? You're just going to mess it up. You're going to give the client bad advice. You're going to get a bad reputation. You're going to feel bad about it. So if you don't know how to do it, you don't want to do it, you don't want to learn how to do it, just refer them to someone else. Requirements for written advice. So when you are giving a client, specifically here, they're talking about written advice, but written can be in an email, could just be in a text message. Anywhere, if you are writing it, typing it, etc., it is written advice. Then you have to meet all this criteria. It has to be based on reasonable, factual, and legal assumptions. You have to consider all the relevant facts when you're giving the advice. You have to use reasonable efforts to obtain the relevant facts. You can't rely upon representations or statements of another person if relying on that other person would be unreasonable, as we talked about before. You have to relate whatever the applicable law is to the facts and circumstances of that situation. And you cannot take into account the possibility that a tax return or issue will not be audited. In other words, you do not want to say to the client, in this case, we're saying in writing, you do not want to say to the client, hey, look, you're probably not going to get audited anyway, so just go ahead and take this position and roll the dice and take your chances. That is a no-no. So you do not want to advise clients to do that, particularly in writing. You do not want to say, chances of getting audited are not very large, so just go ahead and do it. And if you get audited, oh well, you can go ahead and pay the tax at that time. We do not do that when we are advising clients. Relying on the advice of others is not reasonable when the practitioner knows or reasonably should know that the opinion of the other person should not be relied on, that the other person is not competent to provide that advice, or that the other person has a conflict of interest. So an example, when we were talking about assets and depreciation in part 2, I said sometimes with commercial buildings in particular, taxpayers will hire experts, engineers, and other experts to go into a building and determine what is personal property and what is real property, and then they will do their depreciation based on that determination. Well, if you're hiring a reputable engineering firm and they're going out and doing that analysis, then it is completely reasonable to rely on that. But if that taxpayer is just hiring their brother-in-law, who's a handyman, to go out and make that determination, well, it's probably not reasonable to rely on that. First of all, it's the client's brother-in-law, so he's got a conflict of interest. And secondly, just because he's a handyman doesn't mean he is competent to make those kind of determinations. So again, you just have to use your common sense. But you are allowed to rely on people, as we said before, as long as they're qualified and you don't have a reason not to rely on them. When the IRS is evaluating whether or not a practitioner has violated these requirements for written advice, they're going to use a reasonable practitioner standard. So you will see this in Circular 230, and this is what the IRS does. They say, what would a reasonable practitioner have done in this situation? That's the standard that they will use, and the standard that the courts will often use as well. Sanctionable acts. If a practitioner violates Circular 230, then the Office of Professional Responsibility, so you'll want to know that, the OPR, the Office of Professional Responsibility, they can impose various types of sanctions. So the least of those is called a reprimand. So this is a private letter from the OPR where they basically said, hey, you did this wrong. And it's private. It's not published anywhere. So it's just between the OPR, and the practitioner. The next level is a public censure. So they actually print your name and what you did in this internal revenue bulletin that gets published on a regular basis. Next is they can suspend you from practice before the IRS for up to 60 months. So you're going to want to remember that 60 months. And also it gets published in the Internal Revenue Bulletin. Next would be disbarment from practice for at least 60 months and published in the IRB. You may be reinstated if fitness to practice is restored, but it's going to be for at least 60 months. So the suspension is for up to 60 months. Disbarment is for at least 60 months. And then finally, there can be monetary penalty that is imposed in addition to any of these other than the reprimand. So it could be whether it's a censure, a suspension, or a disbarment, they can also have a monetary penalty that is imposed in addition to that. The amount of that penalty can be the gross income derived from the misconduct. So if you were stealing from a client, it can be the full amount that you stole. Or if you got extra fees from a client because you took some outrageous position, then it can be the amount of fees that you were able to get due to this. That can be the maximum of the monetary penalty that can be imposed. Violations that are subject to sanctions. If the practitioner is shown to be incompetent or disreputable, if the practitioner fails to comply with the regulations of Circular 230. So that's basically everything we've been talking about, except for the best practices. You should do the best practices, but they cannot sanction you for not following the best practices. Also subject to sanction is if you, as the practitioner, willfully and knowingly mislead or threaten a client or prospective client. So incompetence and disreputable conduct, what does that mean? First, it'd be a conviction of any criminal offense under federal tax laws, conviction of any criminal offense involving dishonesty or breach of trust, conviction of any felony where the conduct involved renders the practitioner unfit to practice, or giving false or misleading information, or participating in any way in giving false or misleading information to the Department of Treasury or any officer or the employee thereof. So if you are providing false information to the IRS, then that would be considered incompetence or disreputable conduct. More things that are considered incompetence and disreputable conduct: solicitation of clients in violation of Circular 230 or using any false statements. You violate any of those things we talked about for advertising and solicitation. Willfully failing to file a tax return or evading or attempting to evade federal income tax. Assisting or counseling others to evade tax. And stealing any funds. So funds are supposed to go to the client and you took them for yourself, for example. That would be misappropriating those funds. Attempting to influence an IRS employee by threatening them or making false accusations, etc., and so forth. Any disbarment or suspension from practice as an attorney or a CPA. So if you are an attorney or a CPA and you are disbarred or suspended from practice, then that would be considered a sanctionable offense. And knowingly aiding or abetting another person who is suspended or disbarred to practice before the IRS. Any contemptuous conduct in connection with practice before the IRS. So this would be abusive language, making false accusations, or circulating or publishing malicious or libelous matters. So if you're trying to say, hey, this IRS agent has done all these terrible things and you're lying about them, that would be considered disreputable conduct. Willfully failing to sign a tax return when required. So you are a paid tax preparer. If you prepare that return, you have to sign the return. Willfully disclosing tax information unless you are compelled to do so. So you cannot go telling people about your client's tax situation. That is confidential information. Willfully failing to e-file a return when you're required to do so. Not providing your PTIN when you are filing a tax return. And representing a taxpayer before the IRS when you are not authorized to do so. Giving a false opinion, knowingly, recklessly, or through gross incompetence. So that would be a knowing misstatement of fact or law, an assertion of a position that is unwarranted under the law, and that includes those frivolous returns and assertions. Counseling or assisting in illegal or fraudulent conduct, concealing matters that are required by law, or consciously disregarding information indicating material facts are false or misleading. So you can't just kind of put your head in the sand and pretend that something doesn't exist. If you know something that would tend to show that something is false, then you can't ignore that. You have to take that into account. And again, a pattern of conduct will be taken into account in all of these things. If you do something once, that will be looked at much differently than if you're doing this over and over and over again. And when they say gross incompetence, what they mean is that it includes conduct that reflects gross indifference, inadequate preparation, and a consistent failure to perform obligations to a client. So you need to be competent and prepared and to do your work and to be honest, to do all the good things that we all reasonably know that we should do as tax preparers. And if you are not doing those things, then you can be found to be grossly incompetent. Complaints against the practitioners. Most disciplinary cases that come up are usually going to result from either a complaint by a taxpayer or by an IRS employee. IRS employees are required to fill out a form and report you if they believe that you have violated Circular 230. And a taxpayer is allowed to fill out a form and complain about you to the IRS on this Form 14157. The name of the person who made the complaint will not be shared with the practitioner, but even so, if the taxpayer, for instance, is afraid to put their name on it, they can fill out the form 14157 without putting their name on it. They can fill it out anonymously if they want to. What happens when a complaint is made? Well, once it's made, the Office of Professional Responsibility is going to investigate. If they investigate and they believe that a violation has occurred, then they will send the practitioner a notice, this pre-allegation notice. And then the practitioner can respond to that. If after the practitioner responds, the OPR still believes it's occurred, then they are going to recommend a sanction, and then they will try to reach an agreement with the practitioner. So they'll go to the practitioner and say, hey, look, we believe that this is what you did, and this is what we propose to do. And they try to come to an agreement. And of course, the practitioner can have a lawyer represent them or whatever. They don't have to just go it alone, but they'll enter into a negotiation. If they cannot agree, then the OPR will draft a formal complaint, and they will refer that case to the office of the chief counsel. And then at that point, the practitioner is going to have one more opportunity to try to resolve it before there's a formal disciplinary hearing. When a formal complaint is issued, it has to be specific. It can't just be a general allegation that you are incompetent. It has to say what you did or failed to do that makes you incompetent, for example. Or it has to be specific about what the practitioner did or did not do. And it has to give them at least 30 days to respond. So again, you want to remember that 30 days to respond. When the practitioner responds, they have to honestly respond to each allegation. So if there's a list of allegations, they have to go through each one and either affirm or deny it. If they don't respond, if they just leave it blank, then that will be considered an affirmation. Basically, you're saying, yes, I did this. If you don't specifically deny it, you are agreeing that you did it. When there is a hearing, it will be with an administrative law judge, or ALJ, and the standard of proof is clear and convincing evidence. So it's not beyond a reasonable doubt as it is in a criminal trial. It is clear and convincing evidence. At this hearing, the practitioner can represent themselves, or they can have an attorney to do so. Of course, I would recommend that you have an attorney do it. It's like going to a criminal trial. You don't want to represent yourself. Even if you are an attorney, you want to have an attorney represent you. Once the judge hears this, the ALJ, they have 180 days to make a decision. So that is a number you will want to remember for the exam. They have 180 days to make their decision. And once they do, either side can appeal within 30 days. And either side can appeal. The first appeal is to the Treasury Appellate Authority. At that point, if the practitioner wins, then it is over. The government cannot appeal anymore. If the government wins, the Treasury Department wins, then the practitioner can appeal to the U.S. District Court. So the practitioner, but not the government, can appeal to the District Court. Suspension or disbarment. If a practitioner is suspended or disbarred, while they are in that status, they cannot practice in any capacity before the IRS. So we talked at the beginning of this video about what it means to practice before the IRS. If you are suspended or disbarred, you cannot do any of those things. However, you can still do the things that are on this list. You can still represent yourself in any matter. So obviously, if it's your own tax matter that's before the IRS, even if you're suspended or disbarred, you're still allowed to represent yourself. You can still prepare tax returns for clients for compensation. So there was this case, the Loving case, a court case, where the government tried to say that this person who was disbarred, this practitioner, could not accept money for preparing tax returns, and the court disagreed and said, yes, they can. So they could not represent that taxpayer before the IRS, but they can prepare the tax return and accept money for that, even if they are disbarred. The person who is disbarred or suspended can also appear before the IRS as a fiduciary if they're legally authorized to do so. They can appear as a witness for a taxpayer. They can furnish information at the request of the IRS, and they can receive IRS information pursuant to a valid tax information authorization. Preparer penalties. So preparers are subject to penalties on improperly filed or fraudulent returns. And there are a number of specific penalties that can be imposed for various infractions. So first of all is substantial understatement. What does a substantial understatement mean? It means an understatement of the net tax payable or an overstatement of the net amount refundable. Either of those can be a substantial understatement. For a substantial understatement that is due to an unreasonable position, this is when the preparer knows or should have known that it was unreasonable. The penalty is the greater of $1,000 or half of the income that the preparer received or would have received for preparing the tax return. So it's the greater of those two. And the penalty may be abated if the position is disclosed on the return. So remember, we did talk about that. If it is a completely frivolous position, they are not going to let you get out of it just by disclosing it. But the IRS may, at their discretion, if you disclosed it, even if it was unreasonable, they may abate that penalty, unless it's for a tax shelter or any position without any type of reasonable basis at all. So the penalty is only going to be abated if there was some sort of a reasonable basis, even then, not if it is a tax shelter. There's also a substantial understatement due to willful or reckless conduct. So this is if the tax preparer makes a willful attempt to understate tax liability, or if that understatement is due to reckless or intentional disregard of the rules or regulations. In this case, the penalty is the greater of $5,000 or 50% of the income the preparer received or would have received for preparing the return. So the difference here is that it is willful or that it is reckless. On the previous slide, when we talked about the substantial understatement, it didn't necessarily have to be willful. It just could have been because you were not very good at your job. This is not because you're just not very good at your job. This is because you were willfully understating the tax liability, or you were just intentionally disregarding the rules. Like, I don't want to know. I'm going to pretend that I don't know about this. That would be what we're talking about here. So in that case, the penalty is greater, $5,000 instead of $1,000. Other penalties, and these are all the 2023 amounts, and these do increase each year with inflation. But for the 2024 enrolled agent exam, which covers the 2023 tax year, these are the amounts. So you're going to see for all of these things here over the next several that we're going to talk about, it's $55 per return up to $28,000 in total for the year. So failure to furnish a copy of a tax return to a client, you have to give the taxpayer a copy of their tax return. If you don't, $55 every time you don't do that. Failure to sign a return, failure to furnish your PTIN on a return, failure to retain a copy of a return or a list of returns prepared. So if the IRS comes to you and says, hey, we want to see all of the tax returns that you prepared, or we want to see a list of all the tax returns that you prepared in a particular year, then you have to be able to show that to them. If not, you are subject to this penalty. Failure to file a correct information return. So that would be 1099s, W-2s, etc. Same penalty. Then we get to endorsing or negotiating a client's refund check. Are you ever supposed to do that? No, no, and no. You are not. If you do, $560 penalty per check. If you fail to exercise your due diligence for those credits that we talked about, we have to fill out the form. $560 per return that you do not do your due diligence. For promoting abusive tax shelters, the penalty is the lesser of $1,000 or 100% of the fee the practitioner received or would have received for promoting the abusive tax shelter. Disclosure or use of tax return information without the client's consent. This can be either civil and or criminal. So the civil penalties is $250 per disclosure, up to $10,000 a year. However, that goes up to $1,000 per disclosure and $50,000 per year if it deals with identity theft. And criminally, the penalty is up to $1,000 and or 1 year in prison, or $100,000 if it is in connection with identity theft. So unfortunately, there have been tax preparers who have stolen the identity of their clients or who have sold the information to others to steal their identity. And so when that happens, the penalties are increased. Penalty for aiding or abetting an understatement of tax liability is $1,000 unless it is a corporate tax return, then it is $10,000. For fraud and fraudulent returns may be filed with the cooperation of the client or without the client's knowledge. So, for example, the preparer gives a copy of a return to a client, and then after the client leaves, they add bogus deductions and credits, and they change the bank account information to redirect the refund to the preparer. So the client didn't know anything about this. As far as they knew, they just had a regular legal tax return, and the refund is going to come to their bank account. But after they leave, this preparer changes things, makes it a bigger refund by putting on bogus deductions, and then they change the bank account information to their own bank account. That would be fraud. Of course, they could also engage in fraud with the client's knowledge. They could put all those bogus deductions and credits on there and the refund can go to the client, but then the client's going to give the preparer a percentage of that or something like that. So that would be a fraud in cooperation with the client. Preparer fraud may benefit the practitioner directly, such as by stealing a portion of the refund, or indirectly, such as by charging higher fees or obtaining new clients. And in addition to civil penalties, the IRS Criminal Investigation Division is going to investigate any taxpayer or practitioner fraud. So this is where you will often see criminal cases tried, and taxpayers and practitioners go to prison for committing fraud. Those who are found guilty of felony tax fraud or false statements are subject to a fine of $100,000 or $500,000 if it's a corporation, and up to 1 year in prison. Now, keep in mind, this is for every count of fraud. And usually, this is not just one time. This is not just this tax preparer did this once. Usually, they're doing this over and over again for many different clients. And so they will get convicted of multiple counts of tax fraud. And so it can be multiple years in prison and multiple $100,000 fines that get imposed. Those found guilty of filing a fraudulent return or other document are subject to a fine of $10,000 and up to 1 year in prison. So this can be instead of or in addition to the other conviction, depending on the circumstances. So that, my friends, is the end of video 1 in part 3, covering practices and procedures. Remember, you will want to study the slides along with Circular 230 and Publication 947. In the meantime, I will see you on video 2.